Your Honor, next we can take Aaron Thomas.
Okay.
And Your Honor, after speaking with Mr. Thomas, he was not comfortable with me signing the rights form on his behalf, and he would like to have an arraignment in person.
And that's fine. Can you hear us all right, Mr. Thomas?
Yes, sir.
All right, very good. This is 3A757954 and 3A757955. When can we arraign him in person, please, Carrie?
Your Honor, due to the holiday schedule, the earliest would be December 7th at 2:30.
Okay, Mr. Thomas, write down December 7 at 2:30 and confirm when you've done that.
Okay. 1 second here.
No, no problem.
Yeah, I got my phone stolen last night, so I gotta do it on my computer here.
Yeah, no problem. Just let me know when you got that in there.
All right.
Did you get it in there?
Not quite yet. I'm opening up.
Okay. Just let me know.
Thank you, sir. Okay, you said December 7th at 2:30, correct?
Right.
All right, yeah, I got you.
And it's here at the Bothell Municipal Court, Mr. Thomas.
Okay, thanks. All right, yeah, I got it down.
Thanks so much for writing that down. And keep that, don't erase that. That's your notice now. You got an actual notice, right?
Well, oh yeah, I mean, I have it on my computer here.
Fantastic. Thank you, sir.
Hey, I hope you have a good day.
The court's found probable cause for the prosecution is charged, so subject to you and your lawyer readdressing this, you to be here on time for all scheduled hearings, commit no criminal acts, don't drive until you have valid license and insurance in your pocket. Any questions about all that?
No, I wasn't driving though.
Good. Please don't unless you have license and insurance in your pocket.
I would
Right.
never drive. Yeah, I would never drive.
That's fantastic. Glad to hear it. Thank you, sir.
You're welcome.
All right. Next case.
Okay, cool. Have a good day.
You too.
Mr. Frank Micho, who is present here on Zoom. Mr. Micho, can you state your name for the record?
For the record, I am the beneficiary of the Frank Anthony Micho Jr. estate. I am the authorized representative, and I appoint you, the judge, as the trustee, ma'am.
Mr. Mohammed.
Good morning, Your Honor.
Good morning. My apologies for interrupting your breakout, but I want to get some of the matters that are already on screen and ready cleared out. Mr.
Okay.
Sullivan and Mr. Moshu.
Ready?
Thank you. Today is a day and time set for the probable cause conference. How are we proceeding, Mr. Sullivan?
Judge, as I was saying earlier, Mr. Micho has indicated that he'd like to represent himself. Hopefully, if it's acceptable to him, I can remain just sort of present for the proceedings in case he has any questions. My recommendation to him is that we demand all of the discovery in the case. We have paper discovery. I'm forwarding that to him, but we don't have any of the digital discovery. So we are requesting all of that. And then I'm also recommending to Mr. Micho that we schedule the case for a preliminary exam. And I'm happy to be present for that as well.
Mr. Mohammed?
Yeah, Judge. So I don't believe we had an attorney on record on file for this case, and that's probably why discovery wasn't sent over. Also, I believe we're missing some stuff as well, and we're in the process of getting them as well. If Mr. Sullivan's going to be the attorney moving forward, we'll send it to him. But if he's no longer going to be retained, then I don't know. I don't think it's useful to send it over to him. So if we can know who the attorney is moving forward, we'll send that discovery to that attorney.
Mr. Sullivan, are you formally making a request to withdraw from this case?
Judge, maybe my request is that we have an adjourned PCC for me to meet with Mr. Micho and discuss this further, unless he'd like to make a decision just here and now. Perhaps one adjourned PCC and some additional time for Mr. Micho and I to discuss this. We can come up with an arrangement where I'm at least receiving the discovery, on his behalf and trying to facilitate this for him. But I do want to respect his desires to represent himself.
And Judge,
Sir,
the people would have no objection to any adjournment. And if Mr. Sullivan is the attorney moving forward, please just send me an email letting me know, so that way I can make sure digital is sent to you.
Mr. Micho, were you able to hear Mr. Sullivan just now?
Yes, ma'am. I heard everything that was said.
And was that a reasonable way to proceed at this time? I'm sorry.
Oh, no, and I still stand as being the beneficiary of the estate and point you as trustee, and demand that this alleged debt is discharged from my account, from my exemption account. As I sent over copies of my birth certificate, as well as an affidavit. I don't know if you received it, but it's been sent certified mail. And that is me standing as making this special appearance today. And with the challenge of the jurisdiction, since I have not really been fully told, or I really don't understand really the allegations or the nature and causes of this allegation on my estate.
Sir, I'll interrupt you just for a moment. In as much as you've indicated that you don't understand or have not been fully apprised of the nature of the allegations, we will adjourn this matter over for 3 weeks. That adjourned PCC date will be
December 20th at 8:45 with Judge Oakley.
the adjourned PCC date will be December 20th, 2023 at 8:45 a.m. That's in person in courtroom number 2 with Chief Judge Brian Oakley. And between now and then, Mr. Sullivan, you have the opportunity to speak with your client, bring him up to date on the status of these matters and explanation of the charges against him. And if you want to, at that time, have a conversation with Judge Oakley about how you be proceeding or not proceeding as counsel, that would be the time to do it. Is there anything else, Mr. Mohammed?
Nothing from the people, Judge. Thank you.
Anything else, Mr. Sullivan?
Judge, I apologize for the inconvenience, but I am in a sentencing that morning of the 20th. I don't know if does the court have availability like later in the morning. I could make it work late morning on the 20th or in the afternoon on the 20th.
10:45.
That'd be much better. Thank you very much.
Thank you. 10:45 on December 20th. That concludes this matter. You're free to go. You have a good afternoon.
Okay, it's under the barcode though. This is what you signed up to do. You're a public servant.
Unless you are a price on a can of beans, we don't need a barcode.
And just like that, another sovereign citizen strategy runs headfirst into courtroom reality. Despite all the complicated language, estate claims, jurisdiction challenges, and special appearance arguments, the outcome is exactly the same as we've seen countless times before. The case proceeds normally, the judge remains in control, and the legal system keeps moving forward. But there's an important lesson here. The defendant actually had opportunities to focus on real legal strategy. His attorney was trying to obtain discovery, explain the process, and prepare a defense. Instead, attention kept shifting toward arguments that courts simply do not recognize. And that's where many of these cases fall apart. Because confidence alone is not a legal defense. Now I want to hear from you. Should judges shut these arguments down immediately, or continue allowing defendants to fully explain themselves in court? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.